trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat going wild. We're debating heavy topics but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Hey everybody, happy Saturday. Happy Saturday. Hopefully everybody is enjoying their Saturday, the begin to their weekend. I thank you all for joining me. I said we got so much stuff to cover. I'm like, do I wait? It would be just my luck. I wait, and then we have a trial next week, right? You know, because right now currently the only thing I know we doing is Hawaii. But since I got like 3 different things that I need to update you on, and it's probably gonna be 3 different streams, I figure I'll at least get one out the way today, and then we will Monday we'll probably do the other 2 topics that I got that we need to be caught up on, and in regards to where we're at. Yeah. So let's I'm gonna do my welcomes, and then we're gonna kind of go into what information I have today. Hey Christine, hey Bart, hey lady, hey Susie, how are you? How are you? Hey Lynn, hey Carol, hello, hello, hello everyone. Everybody that is lurking and working, or I don't know if you're working and twerking, maybe he's working and twerking because it's Saturday, right? That you could be doing. So for those that we did cover the Delphi redrum case when the first appeal, when the defense requested the appeal, and we went through that. So, and I'll put the link to the description in the description box in case you want to go back and refresh. I will kind of touch on some points that were in the defense one, so you can know kind of what the state is responding to. But Yeah, I don't know. I don't know how this is gonna go. I think that, and I said I'm gonna do a poll, and I probably should put that poll in there now, because it's almost like I think it's harder to get an appeal versus to get a conviction. Do you guys get that sentiment too? Like, it's so much harder to get an appeal. Like, we waiting on Zach Adams. Hopefully we'll have some information on Monday, whether or not after his post-conviction hearing that maybe we'll get an answer on Monday, letting us know if the judge decided to grant Zach Adams a new trial in the Holly Bobo case. So that's what I'm saying. Like, I just don't with everything, especially when it's like blatant stuff in a case. And it's not to say that these people may not be guilty. My problem is that even if they're guilty, we have to make sure that they are prosecuted the right way, because everybody's entitled to a fair trial, whether they the POS that we think like Shonda, or the POS like a Brian Walsh, or a POS like Corey Richards. Like, all of them are POSs in my mindset. But in the same token, we do need to make sure that they have a fair trial at the end of the day. So yeah, so that's my thought process on that. So let me get the document up, and then we're going to get into it. I did. I wonder did I keep them in my clips that we had from the last one. Oh no. Give me 1 second. I want to see if I kept any of the clips that I had from the last time we did it. Because I got one to say Delphi murders. No, I probably don't. Okay. Okay. I'm gonna take my bubble yum out. I'm pretty sure y'all don't want to hear me clicking in the clack. And sometimes my gum gets so actually good to me that I don't know what to do with it. So I know the last time we did go over the phone calls and conversations, and y'all kind of heard how a one person, even from his body cam, from his when we were actually watching his interrogation video, you can see like the complete deterioration and all of that as they went along with that poor person with that interview. Just so we can have an overview of everything, I am going to play kind of an introduction to the actual case for us. So let me get that pulled up and we'll kind of go in there, okay? So this will give us a baseline, and then I'll go over the information in regards to what was found. Because I don't think, and people can comment in regards to, I don't think the guy on the bridge is him. I don't know where they put 2 and 2 together, but yeah.
Unsealed court documents give us a closer look into the Delphi double murder case, for the first time revealing how the 2 Indiana teenagers were killed. Plus, the accused killer Richard Allen confesses to the murders on multiple occasions before exhibiting bizarre behaviors in his jail cell. For nearly 6 years, this video was the only clue the public
So, I mean, even
had
when we're looking at this video and this guy in here in the video, I mean, like, I can barely tell what voice this is. And he does says, guys, go down the hill or something to that effect. I want y'all to keep this in mind as we going through this and we listening to everything that they are saying that the defense is filing the motion for the appeal for. Richard Allen had went in and he was cleared when this first happened. And I would honestly think because a lot of pressure and things that were going on in the area, I don't want to say they planted evidence, but I don't know how they got the evidence in order to, why did it take 6 years for that evidence to come in order to press charges? But let's see here.
The unsolved murders of Abby Williams and Liberty Libby German. On February 13th, 2017, the 13 and 14-year-old girls were hiking on a trail in Delphi, Indiana. They then disappeared. The next day, their bodies were discovered in the woods nearby. The video was taken by one of the victims the day she was murdered and released to the public as investigators searched for more information. Officials now say the man in the video was Richard Allen. Since his arrest in October of last year, he's allegedly confessed to the double homicide.
And for me, the biggest thing was these documents gave us more context into these so-called confessions we've been hearing so much about. Before yesterday, we knew nothing about the situations where he made these so-called incriminations. Now we know.
That seems like.
Okay, so let's get in. That brings up a good point and a good starting point for us. In regards to these confessions. For you guys that don't know, his confessions, he was very adamant in all his interrogation videos that he had nothing to do with this at all. And then all of a sudden, when they arrested him, somehow, I don't know if it's because it's because of the conditions, is what the defense is saying, because he was in solitary confinement. Like, he was just deteriorating. It was just all bad in that jail cell that they broke him down so mentally that he was like, forget it. I did it. You know, he was tired of his wife going through it and her being worried about him. And I think that he just really gave up hope and just kind of like confessed because just to confess. I really don't think that that was on his own will. And you will know that from when you look at the actual interrogation video. Okay, but here we go. Let's get into this first part of our thing. So what we have right here, and this is from the state, they filed this on 2 days ago. So it happened on March the 26th, 2026. The Attorney General actually posted it on their website. Like, they sent out a bulletin like, we have responded to the defense's appeal. Susie, yes, this is stuff that happened since the trial. Also, please note, guys, this trial was not made public. So there was no transparency. Unless you were in the courtroom, you didn't know what was going on. That's another issue that I have with this case. Not to say that if cameras were in there, that it would have changed anything, but at least we would have been able to see how justice unfold or how justice was not unfolded in this case. And they didn't have cameras in this trial. So I hope that when we actually, if they do decide to give him a new trial, that cameras are allowed in the courtroom. Okay. So the statement of issues. So this is what the defense brought up, and this is what the state is responding. So number one, whether the omission of evidence seized from Allen's home constituted fundamental error. So they also wanted to know whether the trial court properly admitted Allen's confessions. whether the trial court properly excluded and omitted various pieces of evidence, whether the trial court properly denied Allen's motion to correct error. So this right here is everything the defense is challenging. So I guess my question to you guys is, I would like to know, like, between these four things, like, what would matter most to you? And I'll put a poll in here because I kind of want to know as we go along with what y'all thoughts are. So kind of like, I don't want it to be, they changed the way these polls is, but let me end that. Okay. And I'll put this in here so you guys can look at answering it, and then we'll kind of go into each issue and see what the defense requested and how the state respond. And then you can tell me what you think will concept, how this should go. Because I'm like, I get what they're saying, but in the same token, we do want people to have a fair trial. So let me put this in here, the admission of the evidence. Let me see, because they don't even allow me to do so many characters. Evidence from Allen Holmes. Evidence submitted. Oh, his confessions. Okay. The evidence. Included. I want to say omitted. I'll say omitted here. I'm trying to make it because they don't allow me to put so many letters, words, characters here. Submitted. Which makes it hard when I'm trying to make sure y'all understand what the survey is about. Of motion to correct error. Okay. Okay, cool. So we got that up there for you guys. Okay, so there we go with that portion of it. Now we gonna, because of course it is 97 pages long, and if you ever thought Sweet Pea was gonna read it all to you, no, that ain't happening. But what I will do is, if you are a part of our Discord, I will make a Richard Allen room, and you guys can actually look at that. I'll drop it in there, and you can read it all at your convenience, because I know some people like to read the actual arguments and everything. I'll put it in there so you guys can have it. Okay, so I will do that. Okay, so guys, when we talk about the defense frames the appeal around these three major issues. Okay, this is in Indiana. Okay, so they saying, first of all, and this is the defense, right? We know how the state is going to respond to these four things that I just mentioned to you, which is the statement of issues. Let me tell you what the defense had in their appeal summary. And I'll put that also in Discord too, because I have both of them. Okay, so the defense frames the appeal around three big issues. The search warrant. So they feel that a Frank's issue is the cause. The brief says that the search of Allen's home was unconstitutional because the warrant affidavit allegedly omitted key facts, including misleading or false statements, especially about the witnesses, descriptions, the car, and what Allen actually said about his clothing. The defense argues that without those omissions, misstatements, probable cause fails. It falls apart at that point in time. Or at a minimum, Allen should get a Frank's hearing. And so what the defense is saying that we got fruit just growing from the same poisonous tree, right? There should have never been a search warrant because everything that they put on there on a search warrant was false. Like they just made up stuff in order to get this search warrant to search his house. So in his vehicle, in his car. So right there, that's a problem. So without the search warrant, then there's other evidence that does not come in. So let me get down here and I'm gonna break this down on how the state responds. I think it's on page 26. Yeah, here we go. I mean, the state kind of vicious with this. I do want y'all to know. So the summary of the argument. So it's saying, for one, the Frank's claim is waived in several respects, and it is meritless. Legit did not include false statements or omit material information from the probable cause affidavit. And the affidavit still establishes probable cause even if the challenge statements or omissions are excluded/included. So they saying, regardless if he did say something that was incorrect, it still was enough correct information on there to be able to have probable cause to search his home. So I guess when we looking at everything, it's just saying the state is saying that that's part of the appeal for the Frank's hearing. In plain, it just fails. Like they're saying that regardless of the fact, they would have been able to get a probable cause to search his home. Okay. Number 2, confessions. The defense is arguing that the confessions in solitary confinement. The defense argues that Allen's statements while jailed were not voluntary. They said because he was held in an extreme pretrial solitary confinement at Westfield. Now, mind you guys, this is not prison. This is supposed to be like jail. So like, but this was like terrible. They had him in solitary confinement where he was by himself. So he deteriorated mentally, was later found gravely disabled. Like if you see his pictures from his interrogation to my actual thumbnail picture, like I think he in a wheelchair, like he didn't just wither away. And so they're saying that he began making these statements while he was psychotic. Like you can actually hear the deterioration. And guys, if you did not watch the first video when we reviewed this, where we listened to all his jail calls and how he was upbeat, he was ready to fight until it just kind of like they put him in solitary confinement and it just slowly just went downstream. The brief also says that because his statements should have been suppressed at that point in time. So the state responds and they say, well, look, Allen's challenge to his confessions is waived. Regardless, his confessions were voluntary. Now, what I would like to say in regards to these voluntary confessions, guys, and I don't know what this does for you, it wasn't just one confession. It wasn't just 2 confessions. I mean, he made multiple confessions. So, they're saying Allen's claims are waived The court properly admitted these. Allen's confessions were voluntary, harmless error, and the court should affirm. So, the requisite state coercion is absent, and the conditions of his confinement did not rise to the level necessary to constitute coercion. Allen also has not shown that the conditions caused his confessions, as the record provides other explanations for his desires to confess, and he confessed both before and after his period of psychosis. Allen's other state constitutional challenges are meritless. Allen's challenge to the exclusion of the IPAS settlement, I don't know what that is, but whatever that is, at the suppression hearing is mute. They're like, mute. No. And he has not raised any challenge to his exclusion at trial. Regardless, Allen was allowed to present evidence of the DOC policy regarding the SMI prisoners and restricted housing and any minimal probative value of the settlement agreement from an earlier unrelated lawsuit was outweighed by the danger of the prejudice and confusion of the issues. Its exclusion is at most harmless error. So they saying, even if you're saying all of that, this is all harmless error. All harmless error. So it doesn't change anything. So the state is basically saying, even if you pick the case apart, it still doesn't fail. So like, even if you pick every piece apart, it's still going to come back to him being guilty. But you know, my thing is that even if you are considered guilty, we need to make sure we're doing this the right way. Okay. So in regards to the inadmissibility of evidence, the admissible evidence, let's talk about that. So the defense says the right to present a defense / trial errors. The brief argues that the trial court blocked Allen from fully challenging the state's case by excluding defense evidence, including evidence that tied to witnesses' descriptions, right? They had like 3 or 4 composites of different people on this bridge, right? And if I remember correctly, the defense was unable to bring those photos in. They were also not allowed to go down the lane of, there was some kind of ritual, I believe it was, that they said that could happen like this, that they were trying to bring in, that was currently like happening in Indiana during this period of time, where they were taking young women, placing them a certain way, unaliving them in Indiana, and the defense was unable to bring this evidence in. Okay, so they were unable to even provide like a plan B. You know what I'm saying? Like an alternative theory. So it argues that the jury heard improper rehabilitation / hearsay on a timeline issue. So the strongest points is that the affidavit story was incomplete. So we'll go into this portion right here. There was no eyewitness that identified Allen as the bridge guy. The brief emphasizes that although witnesses believe they saw the bridge guy, no eyewitness identified Allen as the bridge guy in trial. So that's kind of important. So the state is kind of responding, and they're saying, look, the trial court properly excluded this admissible evidence. Blair's sketch of the bridge guy was not relevant because she did not identify Allen. It was unduly prejudicial, and it was inadmissible hearsay. Tobin's testimony was not relevant because it went to the admissibility of the firearm identification evidence as a science, not to a witness credibility, and firearm identification evidence is admissible in Indiana. Now, the audio of Allen's movement videos was hearsay. His 2 jail calls on April 3rd, 2023 did not fall under the doctrine of completeness. So, Dr. Grasson's opinion that Allen's confessions were false were impermissible vouching evidence. So they saying that the doctor, so they explaining why these different items, why they were admissible and why the court's decision to not allow them to come into court, why it was correct, just so you guys know. So Pearl Mutter's third-party motive testimony opinion, this was a ritual killing, was properly excluded up under the evidence rule 403. It was impermissible, speculative, unsupported by the odiness, who could be connected to the crime. So that's what that's the ritual killing that I was talking about. I guess it's called odiness. Y'all can tell me. Y'all know I can't pronounce shit. Y'all know how I get. So was the crimes. And so they didn't bring that in. But if they were positioned, guys, from my understanding, the way the young ladies were positioned, that it looked like it could have been part of this ritual. And not only that, guys, there was another man, there was another person, I believe the property that the girls were found on, the guy who owned the property, even though he's passed away now, he was already charged with like sex crimes and things of that nature. And I believe his ex-wife, who was being abused and had different things going on, she actually called the police and she believed that it was her ex-husband that was in these videos and stuff. And remember, these girls were found either on his property or near his property. And they did not do anything to go down that road to investigate him. And now he's passed away at this point in time. But it really concerns me in some ways, because like, how did y'all not know it was him? Especially he was somebody that was already convicted of some sex crimes. Like, why didn't y'all investigate him more? And his wife had called in and said, hey, I know him, his ex-wife at the time. So they were never ever able to address this extra, suspect. So here it comes in. It's saying Allen's proffered third-party suspects were unduly speculative and did not tend to show Allen had not committed the murders. Holder had a confirmed alibi. This is what the guy that went to go get the tub. They went to go get some old tub or some crap, him and his wife. And that was quote unquote his alibi. Making it impossible for him to have committed the crimes. And Allen never contended that Westfall, whose sole alleged connection to the crimes was his onanism, could have committed the crimes by himself. So any error in the exclusion of any evidence was harmless beyond a reasonable doubt based on the eyewitness testimony and Allen's statement, placing himself at the scene. Remember, he said that he was on the bridge or near the bridge I don't think he said he's seen these young ladies, but I know that he went home and he told his wife, and what I'm talking about is Richard Allen went home and told his wife, and he was like, well, should I, notify the authorities because they had seen it on the news. And that's how he ended up going down to the station, kind of letting them know, hey, I was there. So he kind of placed himself at the scene, which combined with to the identity on the Allen as the bridge guy. So that's how they kind of, I don't know. I guess they kind of like, they just put it together. They decided that they was going to put it on him. Now, this is what I didn't understand. The presence of a .40 caliber cartridge cycled through his gun at the scene and his numerous confessions. Now, this part right here is what I do not understand. I do not know how one of his calibers, and I know that they may do like hunting, I don't know, maybe hunting in this area or something to that effect. How did one of his cartridge that cycled through his gun, unless it was planted there? Because I can almost believe it was planted there because it seemed like they had to do things. Now, I'm not sure exactly when they found this .40 caliber cartridge, but yeah, it could have been planted there as far as I know. So that's what we have in regards to that. So now then we have the omission of the Google search for alternative theory explaining the cell phone's audio output code was harmless error. None of the theories for that code made it more or less likely that Allen killed the victims. Okay, so they saying no matter what, it don't matter. It doesn't change anything of any of that. So the motion to correct the errors / false testimony section of the Van timeline, because that is sharp, right? So, and that was what they really talking about in regards to the appeal. Let's see here. So I told y'all about what they said in regards to the defense, and that's their response in regards to that portion. Now let's go down and get into these confessions that he has on. I try to put the pages on here. So that's on 44. And I tried to kind of read through here so we wouldn't have to go here. This another big one is affidavit that did not contain the false statements in regards to this portion. They got such a mess going on with that part. Let me see. So this is the affidavit in regards to the false statements, like where people were reported seeing muddy and bloody. They say a muddy and bloody man who was wearing a blue color jacket and blue jeans was not a false statement, much less one made knowingly, intentionally, or with reckless disregard for its truth. Allen's claim of falsity rests on the video of that June 7, 2017 interview, where she is only heard describing the man as muddy, not bloody. And she said he wore a tan or lighter colored coat with a dark hoodie or a sweater underneath. And then they have suppression exhibit. It's on page 115. But Carbaugh was interviewed 3 times, all before the warrant affidavit was prepared, and Allen ignores Carbaugh's description of the man in the second and the third interviews, which show that neither representation was false. So they say that Allen okay, let me start back off into here. So maybe I should read this, not skip this part. So legit representation that Carbaugh said that the man was bloody was not false. Similarly, in Carbal's second interview, she corrected her previous inaccurate statement that the coat was tan in that interview. She said that the man wore a blue coat with a brown or tan sweater or hoodie underneath. She also told police that the man in the bridge guy photo was the same man she saw on the road. So this is the one that's saying that she saw him. And the bridge guy was wearing a blue coat, guys. So Legit's representation that she said that the man was wearing a blue coat was not false. Allen cannot prove falsity by cherry picking isolated statements and ignoring the totality of what she said. So they saying, nor can Allen meet his high burden to show deliberate or reckless conduct merely by the fact that Legit's affidavit related to the information from Carbal's more recent statements to police. He can't say that they were false and just kind of like cherry pick that. So let's see. Material. So this is in regards to the probable cause, in regards to what we talked about earlier regarding when they went to go search the house. And this is also talking about Allen also claims the affidavit omitted material information by failing to include details of the Blair's description of the car she saw parked at the old CPS building that were inconsistent with Allen's Ford Focus, and the details of Blair's description of the man she saw at the bridge that were inconsistent with Allen's appearance. Allen did not show that these omissions were designed or misled or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated the probable cause. So they saying, regardless of what you're saying, it was going to happen. Okay. So that brings me to my next question for you guys as we're going along. So my question would be, is that if the police made a mistake on a search warrant, like when we send poisonous fruit from the tree, right? Like, should that like invalidate? I think that it should invalidate any evidence that they receive. So that goes back to that Frank's hearing that we were talking about in the beginning, where, hey, y'all put misleading information in order to submit to the judge. And if you would have submitted the right information or didn't have the correct information, the judge probably wouldn't have signed off on the warrant. This is what the defense is seeing. So everything that you found in that home or in the car should not be brought into trial. And I guess my question to you guys is that if they collected the information wrong, it's fair that that information should not be brought into the trial. So if you can't bring that stuff into the case and it can't be presented in court, does that weaken the state case? I think it does weaken the state case if they can't bring certain things into court. Regardless if it's their fault or somebody else's fault, they have to do things right. And if they didn't have the correct warrant, they shouldn't be able to do that. Oh, welcome in, welcome in. So I see. Oh, hey therapist, hey drunkie, hey support. You say he never had a chance. Let's see. The searches he made about the girls in the bridge were made after the unaliving of Abby and Libby. None of the witnesses would get on the stand and say he was the man. Yeah, they couldn't. They ain't had nobody to get up there and say that. Okay. She said, you just answered a whole bunch of her questions. forensic expert Chris Cecil admitted under cross-examination that nothing on those 23 devices directly linked Richard Allen to Abby, or I don't think anything linked him to it either. Okay, so let's go down here. And like I said, I will put this all into our Discord, because this case is such a rabbit hole case. Like, I know that we had just talked about it when it first happened, so I wanted to make sure that I brought the stuff up. So the portion that I just skipped, this was more about the vehicle, what type of vehicle that he was driving and those things, okay, that we won't get back into. Okay, so now here we go. This is really like a big stinger with me, is that in regards to admitting Allen's confessions. Now, what I would tell y'all is that the state of what they're saying is that, look, when we was going through trial, the defense attorneys didn't say nothing about it. So since you didn't say nothing wrong was going on in trial, don't be trying to bring that stuff up now. That's basically what the state is saying when we read into this. The state is saying, you didn't say nothing when we was in trial. You didn't object. You didn't preserve the record. So now you want to be talking about these confessions? And remember, this was not streamed live. None of that was going on. So just to keep this in perspective, like, so all we can go off is what they're kind of like saying as they're arguing back and forth. And guys, I don't think anything far as you know how some of the trials when we were looking for the appeals, or when people are going for appeals, like even when we talk about Shonda, you know, Vander Ark in Michigan, they show the hearings of the appeals. Or even when we talk about Zachary Adams, they show it. But I guess Indiana is just not showing anything. They're just doing written briefs and stuff. So yeah, there you go. So there's that for that. Okay, so although Allen did not preserve this issue, so they say his attorneys didn't say nothing, the trial court properly admitted the confessions Allen made to his family, Dr. Waller, and the correctional staff. The confessions were voluntary, not the product of the state coercion, and therefore did not violate his due process right against self-incrimination under either the Fifth or the Fourth Amendments, or Article 1, Section 14 of the Indiana Constitution. So his other state constitutional claims are meritless, and the trial court properly excluded the IPAS settlement, which was not relevant to the voluntariness inquiry. This issue is unpreserved. Although Allen renewed his pretrial objections to the confessions before the correctional officers and Dr. Waller testified, he did not request a continuing objection. Wow. So they're saying, you know how we see in court where the judge where the attorney be like, okay, I object. And, you know, they kind of get tired. I guess they can almost get tired of standing up and objecting, to the point that they ask for a continuous objection. And what the state is saying, look, we went back and looked at the transcripts and looked at everything, and they didn't ask for a continuous objection. They objected a couple of times, but they didn't ask for a continuous objection. So we thought that we were good. So more importantly, he affirmatively stated that he had no objection to the documents memorializing his confessions to the correctional staff and Dr. Waller. And he objected only on a different basis to the recordings of his confessions to his family. It's kind of funny that they saying Allen, like it seemed funny because they're saying Allen, and Allen was not the person objecting. It was his attorneys, but I guess they have to say, like, they directing like Allen, Y'all see how they saying, although Allen renewed his pretrial ejections, it just seemed funny because Allen ain't did shit. You know, his lawyers did this. So let's see here. Okay, so it says state at the trial that he has no objections to the admission of the evidence, and then claims such an admission to be erroneous on appeal. So they saying that, look, he had no objection to the admission of the evidence, and then now he want to claim such admission to be erroneous on an appeal, guys. And he does not argue fundamental error. Really? That's what we doing? Thereby waiving that claim. The court should find this issue waived. Let's see. So this is more in regards to his statements that he made. And they're just basically saying in these ones that they something else. Boy, look at this. So up under this one, I just seen something in here that's crazy. Like they saying coercive state action is a necessary predicate to the finding of involuntariness under the federal Constitution. The Constitution is not concerned with moral or psychological pressures to confess, right? And then I just seen down here, it says this remains true even when a defendant suffers from mental illness. Defendant's mental state is not enough to render a confession involuntary in the absence of a coercive police activity. But if you break somebody completely down, when you first start looking at his interrogation, he's adamant, no. Remember, he turned himself in and he was clear before. I don't want to say turned himself in, but he had met with the police before years prior. And they let him go. So basically what the state is saying, that even if he had the defendant's mental condition that impaired his cognitive sufficient to render a confession involuntary for the purposes of due process, did not render, even if it's actively psychotic or delusional, defendant can give voluntary confession. So they saying even if you having a mental health issue, you can voluntarily confess. So I think they kind of saying in here that they don't care what his mental health was. They said he was confessing before, after, during this period of time in regards to what happened. So I thought that was kind of important. And then what's the next point that we got in here, that the state, so they saying that his confessions were not caused by the allegedly coercive conduct. That's messed up. Because you can actually hear where he just started confessing, because if you not eating, I heard it was periods of times that he was like eating his poop and all types of stuff. So this is like crazy. How you believe anything that comes out of somebody's mouth that is going through that? That is like crazy. So I say for the confessions to be involuntary, the cohesive state action must be causally related to the confession. Allen's argument assumes that the condition of his confinement caused his brief period of psychosis and His psychosis caused his confessions, but both premises are belied by the record. Moreover, the state did not attempt to deliberately exploit Allen's confinement or his mental illness to procure a confession. I don't know. You keep me away from my family and things like that and weaken my mental mind. And he didn't want his wife going through that. And I think he just really, really gave up. The confinement conditions did not cause, and I heard it was times that they stopped him from even seeing her. So like he couldn't even see her. And she started when they was even having their phone calls. I can remember when we listened to him, she was like, if you about to talk about that, I'm about to hang up. His wife was like, I'm about to hang up. So the confinement conditions did not cause Allen's confessions. The conditions did not become more oppressive before the confessions began, nor did they become more before Allen stopped confessing. And the state never made any threats or promises regarding those conditions predicated on his cooperation or willingness to confess. Moreover, the confessions were not coextensive with Allen's period of psychosis. He began confessing before the psychotic, and he continued confessing after he was no longer psychotic. Allen was already confessing in early April 2023. But it was not until April 13th that Allen became gravely disabled, and April 14th that his psychosis and manic behavior became significant and was involuntarily started on an antipsychotic medication. Yeah, and I don't know who is this Dr. Waller. I don't know who that. I can't even remember who that person is and stuff. But who is that? Is that a state doctor or something, like a hospital doctor from the jail? Because if so, I don't trust that person. They talk about after spending time in Bible study, Allen has said that he found Jesus and accepted God into his heart. Y'all remember that phone call where he was like, I accept Jesus? He was talking to his mom on the phone. I believe it was his mom on the phone at that point in time. Let's see here. So they're saying Allen's other state constitutional challenges are meritless. The omission of Allen's confessions did not violate the due course of law provisions in Article 1, Section 12. Criminal defendants do not have any general due process rights under Section 12. Due process in criminal cases is protected only through specific rights guaranteed by other provisions in Article 1. Thus, under the state constitution, the use of involuntary confessions is prohibited only through the Section 14 privilege against self-incrimination. It says Allen has waived his claim under Article 1, Section 15, because he raises it for the first time on appeal. In his motion to suppress and at the pretrial hearing, Allen alleged violations only under Sections 12, 13, and 14 of the Indiana Constitution. At trial, he merely incorporated his arguments from the pretrial hearing. So they saying because in pretrial he had these arguments and objected to these things, his lawyers, guys, they did not object and they did not bring these things up when he was actually in trial. And so they're saying, oh, so now in the appeal you want to be saying something. Well, no. The state is saying basically, no, dog, if you didn't bring that up during the trial, don't be bringing that stuff up now. That's what the state's saying. I don't know. So they saying like Allen did not preserve this issue for appeal. He waived this, you know. And I want to, when I say Allen, y'all, I'm talking about his attorneys, right? There was no objections. There was no false statement. So, and we do have probable cause. So they saying even if the confessions were involuntarily, their admissions into the evidence is harmless. They saying even if they were voluntarily, like it was harmless. And the erroneous admission of involuntary confessions is subject to harmless error review. Constitutional errors must be harmless beyond a reasonable doubt, meaning that they did not contribute to the verdict. So they saying even if you take his little confessions out, even if you take his confessions out, basically what they're saying is that that's a harmless error, and it wouldn't it did not contribute to the verdict. So they say in the timeline, eyewitness evidence, including Allen's initial statements to the police alone, creates an overwhelming certainty that Allen was the bridge guy. So they said they don't care if you take out his damn statements. Look, we got enough evidence, including his initial statements to police alone, with the eyewitness in the timeline, that he's the bridge guy. Allen admitted to being parked near Freedom Bridge entrance and began walking a trail about 1:30 p.m., which was corroborated by the surveillance video capturing a car matching the appearance of his Focus driving towards the Freedom Bridge entrance at 1:27 p.m. He admitted he was likely wearing a dark Carhartt jacket with a hood, blue jeans, either tennis shoes or work boots, and had a hat with him. I know this is one day he wished it wasn't nice outside, because this was like an unusual day in Indiana during this period of time where it was so nice outside. The girls was out of school that day, and so they decided to go walk. And I know he wished it was. I think he ended up being off work that day. I bet you this was one day he wished he would have took his ass to work. Good grief. Which matched the clothing worn by the bridge guy. Allen identified himself as the man who walked past the Wilbur Voorhees group on a trail about 1:30. Oh man. So they both immediately recognized the picture of the bridge guy as the man who had walked past them. So they saying, hey, Allen said he walked past Wilbur and Voorhees. I think that's Voorhees. And they said they both immediately recognized the picture of the bridge guy as the same man that walked past them. And they said Allen had admitted that he walked past them on the trail about 1:30. Allen also admitted that when he reached the high bridge, he walked out of the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance at or just after 1:46 p.m. And when she reached the high bridge, she saw a man on the platform who she immediately recognized as the bridge guy. Neither Blair, Wilbur, nor Voorhees saw anyone else on the trail that could have been bridge guy or Allen. And Allen acknowledged seeing no one else who could have been bridge guy. Dang. As she walked back towards the entrance, Blair passed AW and LG on their way to High Bridge. And by 2:13, the man that Blair, Wilbur, and Voorhees saw, am I saying that right? I'm probably not saying that right. I'm thinking Jason Voorhees. Y'all know I'm a goofy. I've been made up some names. And the man Allen had effectively identified himself as being. So does that make y'all think anything right there? in regards to what they're saying. So he admitted that he was at the bridge. He admitted walking past this group of people. That group of people saying that the same person that walked past them, which makes their stories kind of like match up. They're saying that that was the bridge guy. I can't believe it, therapist. Oh, shoot. I'm going to start saying Jason Voorhees. So what do y'all think about that part of it? So what I basically read is that Alan said, look, yeah, I was on the bridge. I walked past these people. The people that he walked past, they say that's the same guy as bridge guy. Okay, support. Okay, she says Dr. Waller was the psychologist at the prison. She was Delphi Groovy. Yeah, in the Facebook group. Yeah, I ain't thinking about her. Oh, she was fired. She need to be fired. I don't know how they decided that they should have somebody else, like an outside person, evaluate him and come testify to whatever was going on with him. So the man Allen had effectively identified himself as being was following AW and LG across the high bridge and ordering them down the hill while armed with a gun. By 2:32 p.m., LG's phone had stopped moving, and by 3:11 p.m., LG was not answering the phone when her father called, and she and AW had failed to meet with him to arrive at the pickup. Shortly before 4 p.m., Carba saw a man she recognized as the bridge guy walking westbound on CR 300 North toward where Allen had admitted he had parked his car. His clothes were covered in mud and fresh blood splatter. Given Allen's admissions, placing him on the trail and on the high bridge platform at the right times to be the man seen by Blair, Wilbert, and Jason Voorhees, there certainly certainty that the man that they saw was the bridge guy. The absence of anyone else on the trail who would have been Allen or the bridge guy and the tight timeline, this combined evidence created a connection to the abduction and the murders. The only reasonable conclusion to be drawn is that Allen was the bridge guy. They said shit ain't got nobody else to blame as the bridge guy. They saying, okay, y'all throw out his confessions. We don't care anything about his confessions. Even if you throw those out, we got the witnesses that verified that they were on a bridge. We have a concise timeline in regards to him being on the bridge. And then we gonna even take it a step further. Most significantly, the unfired Winchester 40 caliber cartridge found by the girls' bodies was matched to have been cycled through Allen's 40 caliber handgun. Allen had an identical unfired cartridge, the only piece of the Winchester ammunition found in his house, in a keepsake box. Wait a minute. Talk to me about that. Talk to me about that. Y'all help me understand that. So I mean, I see what I'm reading, but how do we explain this away? Are we explaining this away by saying that they should have never been in the house and been able to get the warrant? Is that what we saying? Because they said most significantly the unfired Winchester 40 caliber cartridge found by the girls' bodies was matched to be having been cycled through his 40 caliber handgun. So how does that go? Hey, real happy. Yeah, I was waiting for somebody to tell me something. Matching unfired bullets is not ballistic science. But what is this about? Where they saying Allen had an identical unfired cartridge, the only piece of a Winchester ammunition found in his house, and they said it was in a keepsake box. What is that about? That bridge guy had a gun and used it to compel AW and LG to go down the hill. An ISP trooper who had listened to over 700 of Allen's phone calls. He said that was Allen's voice on the video saying down the hill. Although Allen had 12 old cell phones, damn, in his bedroom closet, he did not have a cell phone he had told police he had with him on the trail. Like, well, when did y'all come back? I mean, that don't mean he got to keep all the cell phones. Creating a reasonable inference that he destroyed the phone because he knew it contained evidence of his guilt. Well, I don't know about that. Now, that's what I don't know. I don't know about that. So Allen displayed consciousness of guilt by lying to police. Although he originally told police he was on the trail from 1:30 to 3:30 p.m., and the testimony of Wilbur and Voorhees, Jason, proves that he was arriving at the trail, not leaving it at 1:30 p.m. When the police re-interviewed him October of 2022, Allen claimed he was at the trail much earlier from 12 p.m. to 1:30 p.m., showing he understood the damning implication of the initial timeline, and he had admitted. While police executed the search warrant at his house, Allen said multiple times, "It's over." Well, you know, this is my thing. So I'm assuming that they did this search warrant October of 2022. Now, this is where I me personally get the feeling like I smell bullshit, because nobody whose weapon was involved nearby, even if he was the person, is not keeping anything related to that weapon in their house. Like, that don't even make sense. This happened in 2017. This is 2022 when they decided to do. Nobody's keeping that in their house. Or am I missing something? Am I missing something? Maybe I don't have a timeline together. Maybe we need to get a timeline together, because that don't make sense to me. If you did something, like, who does that? Let's see. So let's see here. So there was a lawsuit. Can we look this up, y'all? It says the order and settlement agreement from an unrelated lawsuit against the DOC was properly executed. So was the Department of Corrections sued? Let's talk about that. Let's see. Let me see. Ooh. Let's see what it said. Wait a minute. Ooh. Okay. So it says as of mid 2025, the Indiana Department of Correction, DLC, is resolving over $12 million in back pay owed to 92 Indiana counties for housing state inmates, aiming to distribute the funds after July 1st, 2025. The notable settlements include restrictions on inmate mail, photocopying, and major reforms to the solitary confinement for inmates with mental illness. So that's what he probably fell up under, the mental health solitary confinement settlement from 2016 to 2019, a lawsuit. That's wild. So what they're saying is, just as the ultimate ruling at pretrial suppression hearing is no longer at an issue of a completed trial. So also are the subsidiaries evidentiary rulings made during the course of a pretrial suppression hearing. The available issue now is the evidentiary rulings made during the trial, but Allen challenges only the exclusions of the IPAS order and settlement agreement at the suppression hearing. He cites no authority to support the contention that this is a live issue for appellate review, and he makes no cogent argument addressed to the IPAS ruling at the trial. They saying this shit is mute and need to be waived. So the state just said he ain't talk about shit. They said he ain't talk about nothing. They don't care nothing about none of this stuff. If you throw all this stuff, he's still guilty. They saying regardless of both suppression hearing and the trial, Allen was allowed to elicit evidence regarding the DOC's policy limiting offenders with SMI1 to 30 days in restricted housing. The reason for that policy, they said, because it was detrimental effect to the mental health and caused by social isolation. Like they broke this man down so terribly bad. That's what I'm saying. And there needs to be like a transitional jail. Like you shouldn't be like, until you actually found guilty, they should have you like in a baby jail, like baby jail, kind of like house. That's what I want. Baby jail, kind of like house setting. So you're not taken out, you're not moved from your entire hookup, and you're not like completely traumatized. So basically, the state is saying, even if something went wrong, the state says it don't matter. Let's see what else they got in here. So this is about the sketch of the bridge guy. Allen has waived this issue. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man she saw on the bridge. Rulings on motions in limine do not preserve errors for appeal. Allen did not attempt to introduce Blair's sketch at trial. So it sounds like what the state is saying, guys, is that during the trial, the lawyer did not object, did not try to introduce any of this stuff, even though they may have had some motions in limine excluding stuff. And I'm not an attorney, so I don't know what's the thing behind it. So I'm assuming that what they're saying is that even if a motion in limine was granted during the trial, it was up to the defense. Even if the judge said that that could not come in, the defense was supposed to try to introduce that sketch that Blair did in order to preserve the record. I don't know. Don't ask me. I'm just probably making up stuff. Y'all know I'm just here for shit and giggles. Judge denied pretty much everything for the defense. Yeah, but they saying that the defense didn't even bring it up. Because I'm telling y'all, throughout this entire document, basically what the state is saying, look, they did not bring it up during the trial. So don't be trying to bring this stuff up now. It wasn't a concern then. So, but the sketch was not relevant for this purpose because, as the trial court noted, and Allen concedes, Blair did not make an eyewitness identification of Allen as the man on the bridge. Blair identified Bridge Guy as the man she saw on the platform of the bridge. She did not identify Allen as Bridge Guy. Allen's identification as Bridge Guy came from Allen identifying himself as the man Wilbur and Voorhees saw. So they said because Allen said, hey, I walked past this group, Wilbur and Voorhees, and then Wilbur and Voorhees kind of turned around and said, that's the same guy that was on the bridge. They said he identified himself. They said he identified himself. Oh my goodness. Further, any slight probative value was substantially outweighed by the danger of unfair prejudice and confusion. It was undisputed that the composite sketches are used as an investigatory tool to generate leads and are not used to identify or exclude a suspect. Blair's sketch was an artist's interpretation of her description of Bridge Guy, and it was impossible to remove the artist's bias. The danger of unfair prejudice was twofold. The jury could misuse the unreliable sketch as substantive evidence, and two, the jury could misuse the sketch to exclude Allen when Blair had not, I guess because she didn't even try to identify him as the Bridge Guy. Allen's use of the sketch would have been misled and confused by the jury. So they saying that's why that sketch wasn't let in. The sketch was also admissible hearsay. Okay, so they're saying it was also hearsay. Allen's new claim that the sketch was impeachment evidence is waived. He did not offer it for that reason or attempt to impeach Blair with it. Moreover, it would have been cumulative. On cross-examination, Blair testified that she had described the man she saw as young, boyish man in his 20s or 30s of average height with a body of with brown poofy hair and no visible facial hair or a hat. The jury could compare this description to Bridge Guy and with Allen. Allen makes no persuasive argument that the sketch would have been any more impeaching than Blair's description of the person. Damn. Okay, then they get into Tobin's testimony in regards to this weapon. Everything was excluded. They ain't let nothing come in. They said they ain't let nothing come in. Nothing at all come in regards to this. Wait a minute. Just crazy. So they basically during this period of time is like they kind of like just shutting down any type of theories that the defense is coming up with, any third party suspects, any ritual or Odinism theory, experts saying that confessions were false. They're saying that everything is speculative, unsupportive, or is inadmissible. Interesting. What else we got in here? Oh, this is about the firearm. So maybe we should read this part. Let's see. Okay. So Tobin's testimony was admissible because it was not relevant to an issue before the jury. The two-mark identification has at least two sub-disciplines. So let me ask you, and I don't know, and y'all have to let me know because I'm pretty sure some of y'all are way more familiar with the case than I am. Did the defense try to have an expert come and testify? Or is this sound like this is the defense expert that wanted to come testify? Oh, no, it wasn't, because they said defense expert Eric Warren, also a forensic firearms examiner who used the AFTE methodology, testified that he reviewed the Oberg's report, did not agree with their process of comparing a cycle cartridge with the fire cartridge, and found insufficient documentation to support her opinion. This was a battle of the experts. So, okay, they had their expert. The defense had their expert, and I guess I'm assuming that the jury must have believed the state's expert. I mean, that was a lot to get them around, but my biggest question would be is where did they get these unspent cartridges from? Allen also proffered William Tobin, an expert in methodology. I don't know what that word is. I ain't even about to keep it. Tobin is open critic of the AFTE and all the firearms and identification methodology. He believes his discipline is unreliable and should be admitted in court. Interesting. So they saying his proper testimony went into reliability and admissibility of firearms identification evidence, guys. It says because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren and assign the weight to the evidence. Tobin's proffered testimony was not relevant to the credibility. Tobin is not trained in forensic firearms identification. Does not do firearms examinations and did not examine the evidence. Okay, so they're saying this stuff about Tobin, that ain't had nothing to do with it. It was the battle of the experts, Oberg and Warren. Okay. Hey, Jason. Oh, God. Or I should say milk chocolate. Hey. You say, screw all that stuff that you trying to read. Yeah, I'm trying to read, but I'm kind of like peeking and reading. I know support. I don't know what the heck they talk about a doggone phone from 2017. What kind of phones do we have in 2017? Was iPhone even out in 2017? All right. I don't know what phone I had in 2017. I don't know what. And especially you coming back 4 or 5 years later. You say now the world is right again. Good. Okay, so the audio of Allen's movement videos in the DLC. So Allen presented. I'm assuming they said in defense. I hate that they got this like Allen. Allen presented 15 videos of his movement within the DLC during April through June 2023 to show how environmental conditions affected his mental health, which impacted the credibility of his confessions. The trial court sustained the state's hearsay objection to the audio of Allen's statements. So the jury saw Allen, but they did not hear what he said during those movement periods outside of his cell. You know, I was looking somewhere, guys, and I don't know which podcast or where I was on, guys. This case is so weird. They said that they had people like coming, you know, because remember, they think they some of their theory is that this is ritual. This was a ritual unaliving. And so they said people that practice Odinism were coming to see him or were guards in the prison, and they had like different things on them showing that that's what they practice. Have y'all heard that? Put a one in the chat if y'all heard that about this case. I can't remember what rabbit hole channel I was on, but when I seen that, I was like, what is going on here? And they were saying like they had them like where when his attorney would come, the people that practice Odinism or this ritual, it was like they was kind of like in the room, kind of like recording it. I think I heard something about like they were recording his conversations with his lawyer, or they had the camera on, it was reading his lips or something. I just remember it being really, really, really some funny, funky stuff going on in this jail cell. So they were only able to, they only did the video, not the audio, was relevant to present his environmental conditions. So Allen's sole argument on appeal is that his statements were not hearsay under the evidence rule 801C. So he's saying that they shouldn't have just showed the video. They should have showed the video with the audio, because his statements are not hearsay. But they're saying Allen's statements do not I guess they do not pertain to his state of mind. So they got an exhibit. We'll go down there and look at whatever exhibits they have in a minute. And Allen's attempt to use them for the purpose shows that he was offering them for the truth. He wanted the jury to accept the substance of his statements as true reflections of the contents of his mind. And they're saying a defendant who does not testify during a trial cannot introduce exculpatory statements made outside of the court in order to enhance his credibility, because the statements are self-serving, general, untrustworthy, and not subject to cross-examination. Well, I don't find that to be true, because certain fact that he was just explaining what the conditions look like in the actual jail cell. Like, why would they just showing, the shit on the walls? Literally the shit on the walls. Because remember, he was wiping shit on the walls, and I almost think that they said he was eating the poopy. Oh, gosh. Say further, Allen had adequate other means to impeach Dr. Wallace's testimony, including cross-examination and his own expert witness. So I guess they were trying to get this in to kind of impeach Dr. Waller. Yeah, see, that's concerning, because if somebody really believes, if they really doing that, like, wow. So Allen's two other phone calls of April 3rd, 2023. The state presented one jail call by Allen on April 3rd, 2023 at 5:14 a.m. over Allen's objection that the other phone calls that day at 3:12 a.m. and 8:45 a.m. also had to be admitted under the evidence rule 106, the doctrine of completeness. The trial court ruling that each call in full met the doctrine of completeness was correct. Allen cites to no authority showing otherwise. Okay, so this must have been, okay, so Dr. Grasson's testimony that Allen's confessions were false. Dr. Grasson testified to the effects of solitary confinement, the symptoms of delirium, and that he saw Allen exhibit symptoms of consistent. Okay, so is this, Doctor, was this the expert that the defense brought to the table? Y'all put a one in the chat if this the expert that the defense brought to the table. Because I don't remember. I've been hearing stuff so all over the place, so I don't know. I'm assuming this must have been their expert. Yeah, and this testimony was excluded. This is in regards to the ritual killings. Because they had somebody come in, from my understanding, and kind of explain how these people with these ritual killings are positioned and how it works and different things like that, and how the young ladies were positioned that was very similar to these ritual killings, but they did not allow this testimony in. Yeah, and they sacrifice of children would be contrary to the principles of religion. Really? Wow. So this is saying while that was because I don't think they let this person testify. Then evidence of the two-party suspect. Oh, okay. So the trial court properly excluded Allen's proffered of an alternative suspect evidence pertaining to Brad Holder and Patrick Westfall. Allen was permitted to present evidence challenging the quality of the police investigation and their long-term suspicion that more than one individual had been involved in the crime. But the court excluded his specific third-party suspect evidence because Allen failed to establish any nexus between those individuals and the crimes. I mean, but wasn't the girls found next to somebody's property that was a SMEX had a SMEX conviction, and furthermore, his wife had called in and said that he, was aggressive or abusive towards her, and she identified him. The police investigated Holder and Westfall and never found any evidence connecting them or any other alleged Odinist conspirator to the murders of placing them at the High Bridge Trail that afternoon. And Allen's proffered evidence amounted largely to evidence that they were adherents of Odism, and that the sticks placed around the girls' bodies were purportedly in configuration similarly to runes on Holder's social media. They said that falls short of creating a non-speculative connection to the crime. Holder had a confirmed alibi that made it impossible for him to have kidnapped and murdered the girls shortly after 2 p.m. on February the 13th, 2017. When he was interviewed by the police on February the 17th, 2017, Holder said that he was at work on February 13th and he went to the gym in Logansport where he lived. Holder worked in a landfill in Buffalo, Indiana. His work records confirmed that he was at work on February 13th from 4:45 a.m. to 2:45 p.m. And his gym record showed that he checked in at 4:08. Okay, so he probably do got a clean one, right? The operations clerk for the landfill, the only person who could make changes to the electronic time records, confirmed that she had not changed Holder's record. So we can kind of say that Holder wasn't, in there, right? So even though he may have Odinism on his social media, because he had those things on his social media, but he had such a tight alibi, right? That kind of excludes him from that. So I could see where they wouldn't want to, because they really don't have anything to actually bring in for him. Mm. Mm-hmm. So basically it's saying harmless error. Any of these alleged errors, individually or collectively, is harmless given the powerful independent evidence of guilt. The timeline, the eyewitness evidence, including Allen's initial statements to police, creates overwhelming certainty that Allen was Bridge Guy and thus the murderer. Allen admitted that he parked near Freedom Bridge entrance and began walking on the trail about 1:30 p.m., which is corroborated by the surveillance video capturing his car, matching the appearance of his Focus driving towards Freedom Bridge around 1:27 p.m. He admitted that he was wearing a dark Carhartt jacket with a hood, blue jeans, either tennis shoes or work shoes, and he had a hat with him, which matched all the clothing worn by Bridge Guy. Allen identified himself as the man who walked past Wilbur and Voorhees' group on the trail around 1:30. Wilbur and Voorhees both immediately recognized the pictures of Bridge Guy as the man who had walked past them. Allen also admitted that when he reached the high bridge, he walked out to the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance at or just after 1:46 p.m. And when she reached High Bridge, she saw a man on the platform who she immediately recognized as Bridge Guy. That sounds like that's repeating some stuff that we already read. Yeah, that sounds like some stuff that was already read. They must be just restating this stuff. The omission of Google searches was at most harmless. Defense witness Stacey Eldridge said that between 5:45 p.m. and 10:32 p.m., LG's cell phone registered a code in the Knowledge C database of an audio output start, which indicated that the headphones or aux. Okay, so they talking about the headphones of the young lady who had passed away, and they was talking about her phone. I remember them talking about that on one of these sites that I seen. I never figured that out either, but so they say in the trial court properly denied Allen's motion to correct that error. What else they got in here? Oh, they can even put their exhibits in here. So basically what they tell it, Holder is a suspect. His pictures on his Facebook were identified to the currency. His cell was also dating Abby. Yeah, I mean, I get what you stand support, but if his alibi is what his alibi is with him being at work and him punching in and punching out, I don't know what you do about that. Like, what are you going to do with that? And going to the gym. So it seemed like he had a pretty tight alibi. You too, real happy. Yeah, so that seems kind of weird in that regards. So basically what the state is saying, that even if the defense is right, it still doesn't change the verdict. The state is asking for one thing, guys, and that's to affirm the conviction. So I don't know when we supposed to get another update in regards to it, but hopefully sometime soon. I don't know how long they take. It doesn't seem like I said, it doesn't look like they do oral arguments or like where we're going to see this live in any courtroom. I am going to drop these into Discord for anybody that wants to go down the rabbit hole. I will help you go down your rabbit hole. I don't know. When I started listening to it, when we covered it, Richard Allen. When we covered it the last time for part 1, it was the first time I had ever heard about the case. And so I was really like taken back from some of the information I had found out. It to me was like very troubling, like in regards to that, like just knowing that, first of all, I was mad because it wasn't televised. And then I'm like, well, wait a minute. What about all this other stuff? And I was listening to his phone calls, and I'm listening to how he just was so deteriorating right before everybody's eyes. Like, that was so troubling to me. So my whole thing is that even if Richard Allen is considered to be the person who did these crimes, like, we got to do this the right way. And I think the problem is that they have damaged everything because of a certain fact that the way they let his mental health and everything kind of deteriorate because of his conditions in the jail cell and what they were doing as far as his confinement. So these are all the cases that, I will say that with their briefs, like they have they write this stuff out. So they even have like they got the look, they got it all here. They got the page numbers, where the stuff at, what you need to do, statement of fact, like they got it all written out for you. And the defense did the same thing. Yes. What question do you have for me, Jason? Dang, Jason said guilty, guilty, guilty. Golly, guilty of what? You don't even know what he's guilty of. What is he guilty of, Jason? Sure, I can drop the link.
Can you hear me?
Yeah, I can hear you, but you're not up on the stage. Wait a minute. I don't know why it's not adding you to the stage. Wait a minute. Let me see what's going on with this. You didn't make it where you couldn't put your camera on, right? Yeah, because your camera on. I don't know. I can hear you. Can y'all hear him? Y'all put a one in the chat if y'all can hear him. I don't know why. Oh, maybe. Oh, it's the way I got to present it. Duh. I got to change the layout so 2 people can be on the stage. My bad.
Come on, Sweet Pea.
I know. So it is what it is.
Good afternoon. So my question, first off, yes, I know what homie did, or alleged. Well, I guess he's convicted now. So yeah, what he did, what he was convicted of doing. Those 2, I think it were young girls or whatever.
Yes.
Okay. So my question, you said, I think when I came in, I think your comment or your statement was they should have a maybe kind of jail for people who are not yet convicted but are awaiting trial.
Mm-hmm.
My question to you is, who's paying for that?
I don't know. I mean, it's never
'Cause-
going to happen, but it's something that I think that should be in place. Like, I don't know, whoever paying for the jails now. I don't know, like a
We are.
house or
We are.
okay, well, we need to pay for that.
You
I
see
don't
how
know.
much gas is right now? I ain't paying for nothing else.
Yes, you are. If I
Homie
say you're gonna
needs to
pay for it,
stay
you're gonna
right
pay
where he
for it.
at. If you want to throw crap on the walls, sir, you want to eat boo-boo, sir,
No.
that is your own prerogative. You understand? I'm
Well,
not sending you to no mini camp for you to. Now I find out that you really did do that, and you done messed up everybody else in all these other, in this mini camp that may have been. Now they violent people. Your Odinism or ODB, whatever you want to call it, is infiltrating everyone else in the little mini camp that us as taxpayers have to pay for and fund. No, ma'am. Let them
well, they're
rock
paying
with
for it
the,
either way.
huh?
Because they got paying for it either way because they got a $12 million settlement in the state of Indiana for these bad conditions that they have their prisoners in. So they're paying for it either way. So you want to get it up front or you want to make sure that people are, because I mean, I only say transitional jail cells because we have halfway houses, right? For when people get out and they got to go to a halfway house. So
Yep. And we're paying for that.
So what I would like is for
Mhm.
people who are not convicted is instead of putting them into a hardcore prison, and
You're
I
not.
thought that's how it's
You're
supposed
not.
to be.
That's how it is. You go to jail. That's what
But
jail
he
is.
was not in that. He wasn't in jail. He was in prison. That's what I'm saying. And maybe it was just the way they handled this because it's to my understanding, like you stay in jail and then once you convicted, they send you, outskirts of the city. But they kind of
to
keep you
prison.
close
Prison is
until
for people who are doing, well, at least I don't know about every prison. I don't know. I'm New York prison, right? A lot of people think Rikers Island is a prison. It is a jail, right? And jail is when you're waiting your trial and if you get a conviction of like a year or less. Prison, is where they put you like, at least in New York, like you're going upstate. Now they got cows instead of seeing buildings and all that. You're seeing cows and people on horses. But, and that is for like, more than a year, so 2 years and up. And you're convicted of a crime. So I don't know about Indiana, but I don't think there's anything wrong with that. Now, jail can be bad because you have that time. So people who are awaiting trials, people who have like small misdemeanors, and then you have people who are coming from prison. So if you did 20 years, right, and you're coming home, like you're on your last year of your sentence, you come to Rikers, so you'll get that in between that influx of people who are coming from a hard-nosed prison with people who are awaiting trials, people who have just like a year left on their sentence, or just have a year sentence. So you'll have all these groups of people in there, and things get bad, right? But typically, the system has tried to make it a way where you keep people who are convicted and the hard and there are levels to the jails or the prisons, right? You have medium security, high security, low security. But so I think that the system in place has already tried to, encapsulate all of those, little nuances. But you ain't gonna have a perfect world. And making another system, making another add-on to this system already, you just digging in the in. I'm not talking about you. I see a lot of people with prison reforms and all that. you make the taxpayer has to pay it.
Yeah, well, I mean, I want transitional jails, and besides that, with this case, and maybe that's the difference when we talking about this case, when it makes me bring up the transitional jails, because with this case, like, he went to hardcore prison, so I don't know if maybe if he would have went to like the jail, because him going to hardcore prison, like, they put him in solitary confinement, so it drove him crazy, right? So he wasn't even, and I don't know if they put him in solitary confinement because they didn't have no room at the regular jail, so they had to put him in the prison, so they kept him away from everybody. I have no clue.
So
all I do know is that it messed him all the way up.
So they typically put you in, and I don't know this from firsthand experience, right? I just know it from like watching the Darrell Brooks case, just watching trials. What I have typically seen is, like, if this is your first time going to prison and you got hit with like whatever they hit him with the sentence, it could be shocking. So like, what's old boy's name? From Florida, Charlie Adelson. They put you on on that kind of watch. You feel me?
Yeah.
So it ain't no extra rooms, right? Like, they ain't got like a wing for these people. Like, you gonna be in solitary confinement. You feel me? Like, you gonna be locked down, bro. So the hole, the shoe, like whatever they call it in your institution, you in there. You feel me? So nobody likes it, right? Like, it ain't meant to be fun. It ain't meant to be cozy, right? So yeah, bro, a lot of people go through that. You know what I mean? So hearing the stories of poop on the walls, like, yo, you know what I mean? Like, that's why it's like, man, I like to stay clean and fresh. So, prison life, I'm not going for nothing. You understand, right? Like, so, because you know what it's like, bro. They're going to be throwing, they throw it at the COs, all that. Like, it gets nasty in there. So, um, I just think that was par for the course, in my opinion. So his mental health, sorry, buddy. You know what I mean? Like, it's a bunch of people get in the line. Your physical health. They ain't got the best health care. You know what I mean? Remember dude in Florida who snitched on his son? Why he snitch on his son? Because I don't got the right health care in there, bro. I'm about to die in here, bro. You know what I mean? I'm not doing it. I'm gonna snitch on my own kid to not go in here. So,
yeah, but I think that in this case, this particular case, the way they put him in the confinement, regardless of what we may think, I mean, I totally disagree with this case. Because the way they put him in his confinement, not knowing if he was guilty or not, this was an innocent man. Regardless of what they may have thought, they put him in these conditions that mentally drove him crazy. And that's not fair. And then he started confessing and doing, because he was mentally broken. I don't know if you heard the calls or seen the interrogation video. It is absolutely heartbreaking how he went to. Remember, this is a person that came into the police station after everything happened and said, look, hey, I was up on the bridge, boom, boom, this. He go back home. Then years later, they come knocking on his door because they can't find nobody else to pin this on. And then like, okay, it's you. Okay, so he goes back in, he does his interrogation, he adamant about it. They put him in the jail cell, at first on his jail calls, he was, upbeat, boom, boom, boom. And then you could just hear the deterioration because they was keeping him in solitary confinement. They wasn't feeding them. He had these people that he thought that were part of this ritual stuff. I mean, I just really think that was a bad situation for him. How can you even prepare for a trial to defend yourself? It was points in times where his wife was like, I'm hanging up on you because you did not do this and I do not want to talk about this.
So again, you're right. Let me go back to, I didn't follow the trial, right? Like, when it comes to, it's my own personal mental health, so I got to protect that, right? Anyway, so I caught like snippets, so I don't know all the details as you eloquently have stated them, right? Like I get you. So, but I will push back on you because we can't make a rule for just Richard Allen. You feel me? Um, if we're gonna make a baby jail, right? Like a
You want
baby,
a baby jail.
if you're gonna make a baby, you know what I mean, a baby system for him, like
Yeah.
there's gonna be a lot of people who are gonna want that, and I think that's just like what I mean, it's the
It's
snow.
transitional.
No, it ain't no transition.
Why
But
can't it be
again,
a halfway house?
yo, halfway houses are when you're out, and again, we already pay for that, right? Like the city,
Intro
and
house.
a lot of them are nonprofit, right? Like organizations who have donations, but that's not what we're gonna turn, we're gonna turn on a different topic if we get into this, and that's like anyway. But so prisons and jails are not donated, right? Like it's a big machine behind it, whether you like it or don't like it. But it is a system we have. So creating something else, I'm talking about to incarcerate or to confine people. We're not talking about, hey, you need to transition out of confinement. We're talking about confining you for or punishing you for an act or your behavior, right? We're already paying for that. The society as a whole is paying for that. I don't adding something else to society's bill for people who are 90% of the time, you got the right guy. You feel me? Like, yeah, there's so y'all know me. I'm always with the guilty because the numbers are there, right? The numbers say nine. I don't gotta watch this. That dude's guilty. But I do like to see the ones who could Karen Reed's, all those. But anyway, so making a baby system for them is for the people who do, like Charlie Adelson would have been in there. You know what I mean? Like just think of it. Donald Adelson would be in there. The people Shonda Van der Ark,
Yeah.
whatever.
She would like to take
She would have got that treatment under your rule. The people that we despise, you're getting one person. And yeah, he ain't gonna be in there by himself. That's all I'm saying. And then you get people who, think of it. Witness tampering when you're in jail. You know what I mean? People were writing last girl, Corey. She was writing the walk the dog letter from her jail cell, right? Like if you got a baby prison, now what? We ain't really monitoring that. We treating you super right. Now I get the guy shouldn't have maybe been in confinement, whatever. I don't know. Again, I don't know the details, but I'm just speaking. If we come up with that as a society, then we're saying, yo, all these people get that treatment too. Like you can't just say Richard by himself. Like all these people who have not been found guilty as of yet should be in this center. And it's like, nah. And we pay for it. Nah, buddy. Nah, buddy. I
So you don't
disagree.
like my baby jail? You don't like my baby? Yeah. Is
Not
that
at
what
all. Richard Allen, you tough it up, buddy. Yeah, knock him on the
shit?
chin.
Nah, he couldn't tough it up. That was sad.
Yeah.
It's so sad.
Nah, tighten up, buddy. Hey, you better get you some some noodle packets.
No, I am not saying that prison should be comfortable. My problem is that when we have people in prison systems that and then they be found to be innocent or they get off not guilty or whatever the case may be. Not to say that that's the bulk of it, but I mean I can see like you wasting your time in jail and then you found not guilty. Like
You sue them. You sue.
sue
That's
for
what civil.
what?
A lot of people wrongful convictions, right? Like you took away, what I
Not
mean?
wrongful conviction. I'm talking about like
Yeah,
if
not guilty. Then I get you. But there are people who have sat in prison and then found out, like, yo, there was
yeah,
evidence that was, left
exonerated
out,
them.
left out of my trial for
Mhm.
particular reasons. There was bias. We can't give you the time back, my dude. So here you go. Here's 15 million. And who pays for that? The city. Again, the taxpayer pays enough. I'm all about, nah, man. nah,
You
nah,
need
man.
Zach. You need Zach here for that conversation because I'm
Yeah,
not about to go into the prison reform. I said I want a baby jail.
that's
Now I don't know
prison
what you
reform right
I
there.
don't know
You
what
want to do something.
I don't
You
know what
want
you
to
want
change
baby
up the
jail, but I
system.
want my baby jail.
Nah, we can't do it. We can't.
What you say? Y'all
My
can't
pocket,
do it. That
my
won't hit the
pockets is
ballot.
tapped. My pockets is tapped enough. I'm good. You see what gas is? Like I said, I'm paying. I'm in Texas. I'm paying, $3.69 a gallon. No,
That
a
ain't
baby
shit.
jail.
That ain't nothing.
Yeah. Wherever y'all
That ain't
from,
nothing.
I hate to hear
Down
what
here is
SD.
it's almost $5. Next,
That's yeah.
you
You
on this
right.
phone cry. You on this thing cry. It's almost $5. I filled up the other day and I said I ain't moving. Oh, they ain't got to
Hey,
worry about me. They sure not to put me in the house.
but you want a baby jail though.
Yeah, I want a baby jail.
You can move then. You got the money. Hey, we all going to Sweet Pea
Ooh,
house. She got it.
Susie. They gas $7.29. I could not be in California right now
You feel me? That's why
at
Teslas
all.
is running that whole state. Everything's electric.
Wow. Yeah, that's where I'm right where Barb is at. Yeah, we paying about four. I paid about four something the other day, and I was like, I can't even do it. Like, your gas gonna be a car note in a minute, y'all.
But you want a baby jail. I
I
mean,
want a
I don't
baby
get.
jail.
You got it there. You got the money. Don't complain with us normal folk over here
Yeah, I
who
want a
who
baby
complain
jail.
about the jails. Now, because I can't afford the gas, I can't afford a baby jail. I can't afford none of it. I need all my money back. I need
Y'all don't
all
even
of it.
pay state taxes in Texas.
Sure don't. Thank God. One of the reasons I moved here. Thank you. Thank God for Texas. Come on, everybody,
So
put
y'all
it in
got
the
it
chat.
easy already.
Nah, still hard out here. It's hard.
She said Kirby created a toddler penitentiary. I named it the playpen. That's what I want, the baby jail. I'm right there with you, Kirby.
That was
Yeah,
hilarious. But
yeah.
yeah, I just disagree fundamentally with the rule. I get homie might have got a bad treatment, and you know, there are gonna be like, because the system is not perfect. There are what, like, don't quote me on it, but like 300 million people in this country. Bro, joint's not, it's not gonna be perfect. But if you got a conviction rate like overall, it's like nine all across the country.
Mm,
Like 90%. Like, bro, all right, yeah, you get a few wrong. I get it. But if it was a large part of it wrong, yeah, all right, there's something wrong with this system. But 90%, I feel bad for the 10%. That 10%'s family, their life gets upside down. But I'm not about to change the rules. I'm not about to change the rules to let 30 more percent get by when
mm,
I get 90% of them. You feel me? We rock it with, sorry, sue me later,
mm.
take our deepest apologies, good luck out there in the world. That's all I'm doing for you. But
Gosh,
creating a new system for you, I will not. And
no
I don't
baby
think
jail.
and no congressman, you know what I mean? You be voted out quick.
What you
One
say?
term.
Nope, you done.
Yeah, one and
Oh
done.
gosh. Oh gosh. Oh gosh. Well,
But yeah, I'll let you get back to reading. I was enjoying it. I was
I'm
just
done
wondering.
reading. I ain't
Oh,
reading nothing else. I'm done. I'm done reading this. I'm gonna drop it in our Discord for anybody that wants to see it. And read over it and kind of go through line by line because people like to go down these rabbit holes. I just wanted to follow up on it because I know that we had covered the first time when the defense asked for a hearing, the appeal, and this was just the state's response. So I'll put all of them in there for everybody to see. And like I said, I'll put the link in there to our first stream that we covered all of this with the video footage. We looked at the jail calls. I think we listened to the jail calls. We also looked at the interrogation video. So we looked at all of that in the first thing because this trial was not live streamed.
mhm.
So um Yeah, we looked at all that information. And then I for tomorrow, I don't know if we do anything tomorrow. Has anybody seen any trials for next week? Well, I got some of y'all on here. Has anybody seen any updates for any trials? Let me check on here real quick.
What's Hawaii doing, Sweet Pea? I was gonna ask you, you know, I didn't want to take you off topic, but I was gonna ask you how you felt about Hawaii's case.
Hawaii does not does not start up back up until Tuesday. In regards to him, I think that he has to come and he has to he's gonna testify. He's gonna have to make the jury believe that it was some type of she hit him first or something.
Do you think he can do it? That's my question. I know what he has to do. My question is, do you think what are your chances? What do you believe the chances are him being able to convince even one person on that jury of anything by the evidence of what you heard so far?
None of them. I don't think. I think he's guilty. I think he's gonna be found guilty.
Oh, Sweet Pea's on the dark side. Come on.
I know they didn't put me onto the dark side. Well, I'm just saying people guilty like y'all before I can even get into the trial.
Yeah.
No, I'm not going with those eyes. I'm not gonna be like you and Lynn. I'm gonna go back to being the Sweet Pea that's like the devil's advocate.
Mm-hmm. So give me one for this guy. Hard to, ain't it?
No, I said the only thing that he can do is convince the jury that it was a scuffle and get up there and cry and say how they got into an argument when they were up there on the hill. He was trying to take his babe out for her birthday. They were going hiking. We got 5 minutes into the trail and she got the telling me about her boo thing and we got to arguing about it, and that's how we got into a scuffle and that's how things happen. That's the only thing that I think that he can do. Now I'm not saying that it's gonna work, but it's the only thing that I can think of.
Do you think he has a chance of convincing someone like you?
No, I don't think he's gonna be able to convince anybody, but he's gonna get up there and say something to that effect. They already told us that he's gonna say something to that effect.
Okay. As long as you're already on it. So there are people who are just, so this guy would be in your baby jail. Just, to tie it all back up. Just think about it.
Yeah, I mean, he can be in the baby jail until it's time for real jail. Yeah, he can be in jail transition. I ain't mad at that. I mean, should they pay? We paying for all the other jail stuff. No, why can't we pay for this? I know. Don't pay me no attention. I'm sorry. I know I don't get hot about paying for gas and all that stuff again. But yeah. Mm-hmm. Yeah, but I don't see any I don't see anything that's up there, guys, that as far as the trials next week. So I think I was gonna do another little small thing. So I think tomorrow we will I'm gonna give y'all a break. And I'll have some stuff scheduled for the rest of Monday, unless I see some kind of trial come through that we're gonna start Monday. But if not, on Monday we will have I gotta do some updates on this Folio stuff, and we also got some YNW Melly stuff. So we got a lot of stuff in Florida that is jumping off that needs to be taken care of. Why you leave, Jason? Darn, you just left? That's rude. I wanted you to dance to the new California song with me. For our Californians, whatever they are. Oh boy, for our new song, our new hit song. Yeah, so that's gonna be basically our plan for tomorrow. Oh, your phone was getting hot. You're so funny. Yeah, so I think that like I said, we will have yeah, so hopefully Monday we'll have a some judgment in regards to our Zachary Adams case. Hopefully we'll get some information in regards to that, a decision on that. So we got a couple things that's working for us for next week. Besides that, if not, then like I said, I will do our our updates on our Florida cases for our ratchetness. If you want, you are able. Yeah, Jason, that's fine. And if you want, guys, if you want to join us on Discord, I am going to drop the link. Hey, Macro, how are you? I am going to drop the link for you guys. If you want to join our Discord, that's where the after party happens. And if you have any trials that you would like for us to replay, please, please, please drop them in the ideas and suggestions. So if we do have any down trial time, we can look at them. Because the only trials that I really kind of know that's coming up is Courtney Clemley, the 4 defendants in the Julio trial are coming up. And those are the only ones that I can think of at this point in time. Yes, support. Anyone can join Discord and it's totally free. Yeah, come over and hang out with us. Sometimes we schedule movie dates and we watch Netflix and chill. And SD has even learned how to share her screen. So she was like running the last screen. Remember, SD, you sharing your stuff on your phone? I think, if she's still in here, shoot, I don't know. Was SD in here? I think she was in here. I don't know. Yeah, she was in here. Yeah, she was able to share her phone. So it wasn't just me that was able to do it. SD was able to do it. So anybody can host something in there. Y'all don't need me. Y'all, if you on your computer, you can go right to our stream room, or you can go to the lounge and or the community hangout. And if you want to do Netflix and y'all want to have a movie night, you are so welcome. Oh yeah, me and therapist, we had a virtual date yesterday for her birthday. And we watched the movie, and no, it was just a virtual date. It was just me and her. I couldn't figure out, I can't fly to Texas. I can't get to Texas right now. And I was like, well, I want to do a virtual date. If we get, I was like, I'm just going to make up some shit. We going to figure it out. She was like, well, what we supposed to do? I don't know. Guess we gonna get on Discord and we're gonna make a private room and we gonna sit in there. So, and then we gonna find a movie. She like, I haven't watched anything. All I watch is trials. I'm like, well, shit, I don't know what to do with that. Yeah, so yeah, that's awesome. So now I know that I can do we can do virtual dates. We can have lunch dates. We can have all types of stuff, night dates, whatever. So yes, please check us out on Discord. It's a very, very, very good place. They say you got to celebrate for a whole month, boo. It's like freezing in my house. I got to cut this air down. You need a date? You want a date, Susie? When you want to have a date? Yeah, we can always have a lunch date. Always willing down for a lunch date, boo. Yeah, I had like brunch. Yeah, so any day we can sit up there and have except for our trial days, you know, it depends on how our trial goes. So we may have to do like yesterday. It just really worked out because we was in Hawaii and it was kind of like, Look at SD trying to get her a movie going. She said we can watch the new jury duty. Yeah, so awesome. Yeah, definitely check that out. And as I stated, I will be looking to see if there's going to be something new for us Monday. If not, like I said, I got some coverage that we need to cover, at least, you know, I'm gonna be whopping with the chopper come Monday, and we can go down there and get gangsta in Florida. You know, they always got some stuff going on in Florida. It's like that's where all the rappers is just having all the issues at this point in time. But yeah, we gonna do something different with oh, here, Jason, I'll drop it. Susie, you gonna come up here for my chair dance party to your song? SD, are you coming up here for the chair dance party to your song? SD was looking so nice today. She dropped a picture in Discord. She was out there for the No Kings March today, smiling from ear to ear.
Can you hear me?
Yeah, I got you on the stage.
Okay.
All you gotta do, bad hair day. Oh goodness, Susie. We family. Don't nobody care about your hair. I got a bad hair day too.
So yeah, happy belated therapist. That's so awesome. So what was last Sunday? Oh, don't give me tomorrow is the 29th. So 22nd. I can't read the comments, sweetie.
I know. I can't even understand why. Oh, they didn't talk about nothing but this. The 22nd. She said, yes, sir.
Oh, there we go.
She telling them to get up here because this they song. SD, and we got Susie and Drunky.
Oh yeah, well, I love the California.
That is the entire internet. Oh gosh,
Californians.
SD, you coming up here? SD, you be coming up all the time.
Yeah.
SD, you coming up?
Awesome.
And Just Shamrock, she had a concert. Just Shamrock out kicking it.
As she should. It's a Saturday.
She said she wanted a concert. I can't remember. She said she in the Bay Area.
Come on.
I don't know. I don't even see
Lynn.
SD.
I didn't see Lynn in the chat. I was gonna ask her how her bracket holding
my
up.
SD boo. I knew she was gonna come up here. Look at her with her hat on.
Hey.
There go that beautiful lady.
Yes.
I'm tired. You want to see my shirt?
Yes.
Unpaid peaceful protester. I don't know if you can read that.
You say unpaid peaceful protester. Like I don't get no money. I'm just out here.
Yep.
And I'm peaceful. So don't be trying to drag me through the mud.
Yeah, I had the no hate sign and the no war sign. So
yeah,
peaceful.
I see it on the thing. Awesome.
Yeah.
Was it really busy? Was it a lot of people there?
I think it was like 60,000 people today.
Wow.
Yeah. And there was a drone up in the sky and it was just staying there. Like it didn't move. It was in one spot the whole time, focused on the march. And I was like kind of paranoid. And then my friend was like, maybe it's just the news. And I was like, yeah, maybe it's just the news. I don't want to be paranoid today.
I know. Thank goodness. Yeah.
But it was a peaceful march.
It was super peaceful. Like when we were leaving, we asked the police if anything had happened, and they said there were no incidents the whole time.
Wow. 60,000 people.
That's awesome. And we were like crammed in like sardines because we had this one path we could walk along the water, and then it just was so many people. It was really hard to move. So it was a long march.
Yeah.
I my anxiety wouldn't take that. I can't do those kind of spaces.
Yeah.
But I mean, I'm just so happy nobody even pushed, knocks anybody down accidentally. You know what I mean? And it started some wow, that's pretty good. 60,000 people on one accord.
Yeah. Well, I smelled some marijuana smoke now and then, so I think everybody was just going to get along no matter what.
Come on, right? I'm telling you.
Yeah,
that is a miracle plant.
It is.
I said I'm gonna get into One day.
Peace.
That's it, right? All your troubles melt away. Think the world would be a lot better. But I'm not gonna get on my soapbox.
Okay. Hey,
Okay.
Jason, Susie wants to know if you're bald.
I am not, Susie. This is a do-rag. It's
Sorry,
culture.
Susie. He's got hair.
I do. I didn't cut it, so I feel horrible.
Oh, okay. There you go, Susie.
No.
You got it, Susie? She's like, oh my God, OMG. She tickled pink.
There you go. Just for you, Susie. I took my do-rag off.
Just for you, boo. Just for you. All right. Well, I'm glad we get one of the Californians up here to dance.
Yeah.
I really like this track too.
Let's go.
Oh, I do too.
All right. I'm hoping it should come through fine because I ain't doing nothing from my end. So
Okay.
All right.
Oh, I hear it. Love this song. Thank you, therapist.
Junkie on the freeway, white claw in a brace. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town.
I don't hear it.
You don't hear it?
I don't, but I'ma just act like
Why
I do.
not? It must be your phone.
It must be.
Let's see here.
She sure can.
No matter where we are, we all meet in the free. We the California's rolling deep. 4 corners, 1 crew, yeah, the vibes align from the coast to the chest.
I don't even know where the beat is, but we gonna vibe out. We'll follow you, sweet pea.
4 names, 1 flame, you can't remix this.
Yeah.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already
I'm always late.
Hold up, I'm here. She dropping
I'm
bombs,
late,
calm,
SD,
cool
I promise
energy, no
you.
matter how
Sing the
far.
song in my head, so I
Rolling
can
every
stay
stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast.
Hey, this is your part, Susie.
Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap.
Is Shamrock
Y'all
here?
good every time, yeah, she mean that.
He's going to a
Heart
concert
so big you
earlier.
can't teach that.
yeah.
The rhythm running, she keep
The
it
No
alive,
Kings
dropping
concert or
love in the
something.
chat, keep the whole thing thrive.
Oh, they had a concert too?
No, it's something about kings in Ireland or something.
Oh,
Drunkie, drunkie, drunkie. This is my favorite part.
California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this. Yeah.
Drunkie.
Oh, yes.
That's
That's
good.
a song for our
Okay.
outro. And it's so funny because, like, when I was thinking of the Susie part, because, you know, I kind of like, because I know, you know, a lot about y'all. So I was like, you know,
I like that part.
telling therapist, I'm like, she is always lost.
Yep.
We go find her, and she always talk about this FOMO. I had to, because she kept using the FOMO, and I'm like, what does this mean? What does it even mean? She first started coming over here, and it was so funny because she was just
Yeah.
lost everywhere.
Fear of missing out.
Make sure you put that she is always lost. So
Mm.
That was a good. That was funny.
I still always lost.
I like how Drunkie's like drinking and driving in freeway traffic. And then it's like drunkie.
Like
That's the best part.
right?
I love it.
Yeah, you have to listen to your song when you're driving on the freeway. Like,
Mm-hmm.
I should have done that today. I was making everybody on the trolley listen to you though, and because I forgot my earbuds. I should have had our song playing.
What'd you say on the trolley?
Yeah. Well, you have to take the trolley. There's no parking downtown.
Oh, really?
Yeah. So the trolley was packed. And so were all the parking lots. I had to go to like 2 different trolley stops to find parking.
Mm.
Yeah.
Wow, interesting.
Yeah.
There's a lot of people. I'm just saying. That's 60,000.
I know.
That is...
Every trolley was totally full.
Mm-hmm.
So yeah, some people had to wait. But yeah, it's been a good
How far
day.
was the march?
What?
How far was the march?
I don't know. I think it was like maybe a mile, or maybe it was like 3/4 of a mile. I'm not sure. We were on the water the whole time though.
Yeah.
It was hot. Oh my gosh.
Is it real hot there? I don't think it's hot today.
It's not hot at my house. My house is like 71, 72 and breezy.
Okay.
But downtown, I don't know why it was so hot. They usually don't get hot down there, but today it was hot. So I had to take off like 1 shirt, but I wore 2, so that's okay.
Well, I can give you a couple reasons. 60,000 people, you know what I mean? Count the ways. So all jammed in on.
That could have been what it was.
Yeah, it's a lot of body heat that's radiating off of everybody.
Yeah. The guys were taking their shirts off. Like,
I bet they were.
Because they could, you know.
Mm-hmm.
I bet you noticed it, huh, SD?
Not as much as you think I would now. I'm not saying there's anything wrong with that either. There were just too many people.
Yeah, sound like it.
Yeah, it was great.
But
awesome.
I'm glad that it had a nice turnout. And
me too.
I seen like on YouTube they got the different video feeds of it. So
they do.
Wow.
Yeah, on YouTube.
So there you go. SD explains that drone, huh?
Yeah, they had different video of people out there marching, getting ready to march and stuff. So
yeah. I had lots of people stop and take pictures of my flag, so I felt like a celebrity for a minute.
Oh,
it wasn't the hat. The hat is lovely, though.
Thank you. No, it was my flag. It was a no hate flag.
Yeah,
and
I see it.
Yeah, so people like that. I think it's like a positive message, but it starts with the word no.
Yeah, right.
It's positive.
Exactly. Awesome. So we have so I'll put in Discord if I find anything, and I've been trying to put our streams in Discord so everybody can kind of like see them for the most part. That signed up for there besides on our link. But yeah, I guess until I figure out something, if not, we're gonna be just Monday.
Alrighty.
All right.
Great seeing you both.
Can't wait.
Thanks to the moms.
Bye.
Great Saturday. Rest of your weekend. We matching. We got on purple. I love purple. All right, guys. Thanks for coming. Thank you all. Thanks to the mods. Thanks to the chat. Yeah. And I guess we'll be up in this joint next week. Well, sometime next week. Monday. All right, guys. Peace.